there were lots of survivors who had decided, for reasons of their own, never to release their names. That determination was represented to people in Congress, and we built it into our federal law that their names could not be released, and yet you published their names, their phone numbers, their addresses, personally identifying information. If Donald Trump can get $10 billion theoretically from the Department of Justice, how much should these people get for a far worse violation of their privacy rights and a far greater danger established to them in their lives?
Do you even know who Chase Mulligan is? You're so obsessed with, you don't, do you?
I'm going to teach you the rules again. You're the Attorney General of the United States. We have rules here.
You're obsessed with him.
You're the Attorney General of the United States.
You're obsessed with Donald Trump. You have Trump derangement syndrome.
Mr. Chairman, I'd like my time restored. I'd like my time restored.
In your district. In your district, and you don't even know about it, about keeping children safe from online predators.
Time belongs to the gentleman from Maryland.
3 minutes before the exchange hardened into open confrontation, the hearing room still carried the restrained formality of congressional oversight. Staff members moved quietly along the perimeter, reporters adjusted their lenses, and members of the committee organized their notes with practiced efficiency. At the witness table sat Pam Bondi, Attorney General of the United States, sworn to enforce federal statutes without selective interpretation. Across from her sat Jamine Raskin, a constitutional law professor who spent 25 years teaching the mechanics of American governance. The collision that followed was not about personality, it was about statutory obligation. Raskin did not begin with political framing. He began with the victims. More than 1,000 individuals had come forward in connection with Jeffrey Epstein's trafficking network, many of them choosing anonymity to protect their safety and dignity. Congress recognized that vulnerability and enacted a federal statute requiring the protection of personally identifiable information belonging to survivors. That statute was not advisory language, it was binding law signed and enforceable. He outlined the scope of that protection in plain terms. Names were to be shielded. Residential addresses were to remain confidential. Phone numbers and any detail capable of identifying a survivor were not to be publicly disclosed. The purpose of the statute was preventative, designed to eliminate the risk of retaliation or harassment before it could occur. Raskin then shifted from legal framework to alleged failure. Documents released by the Department of Justice contained information that could identify survivors. That material, once placed into the public record, could not be fully retrieved. Digital exposure has permanence, and once distributed, it moves beyond institutional control. The risk profile for those women changed the moment their information surfaced. He did not dramatize the claim. He described it as a matter of compliance. If the statute required protection and identifying information appeared in released files, the department needed to explain how that occurred. The issue was not abstract policy disagreement. It was whether federal law had been respected by the agency tasked with enforcing it. Pam Bondi did not directly address the statutory mechanics at that moment. Instead, she reframed the hearing as politically driven scrutiny. That reframing did not engage the language of the statute itself. It repositioned the exchange from compliance to motive. The distinction between those approaches defined the early tension. Raskin returned to the individuals affected. Many of the survivors had concealed their experiences from relatives, co-workers, and even close friends for years. Their decision to remain silent was deliberate and deeply personal. Congress translated that personal choice into a legal safeguard. When government action undermines that safeguard, the consequences extend beyond administrative error. He then introduced the issue of proportional redress. If a former president could theoretically pursue $10 billion in damages in disputes with the Department of Justice, what compensation framework would apply to private citizens whose privacy protections had been compromised? The comparison was not rhetorical excess. It addressed scale and equity. Financial claims at the highest levels of political power receive serious consideration. Exposure that places private individuals at risk warrants equal seriousness. Raskin did not demand a number in that moment. He asked whether the department recognized the gravity of the harm. The absence of acknowledgement became increasingly visible. The hearing room remained quiet, but the stakes sharpened. Oversight exists to test whether executive agencies follow congressional mandates. When the subject involves vulnerable individuals rather than abstract regulation, the scrutiny intensifies. Raskin kept the focus on law rather than personality. His questions centered on process, documentation, and accountability. Pam Bondi responded by introducing the name Chase Mulligan, referencing a separate case in Raskin's district. The relevance to the confidentiality statute was not established. The shift altered the trajectory of the exchange. Instead of clarifying how identifying information entered the released files, the discussion veered toward district-level criticism. Raskin attempted to redirect. He asked what the Mulligan case had to do with the alleged disclosure of survivor information. The answer did not bridge that gap. The exchange grew more fragmented as each side spoke past the other's framework. One addressed statutory compliance, the other addressed political context. At that juncture, Raskin explained how congressional questioning operates. Members are granted specific time to pose questions. Witnesses are expected to respond within the scope of those inquiries. If a witness departs into unrelated territory, the member may reclaim the remaining time. Once time is reclaimed, the witness must yield. This explanation was procedural, not confrontational. It reflected established rules governing oversight hearings. The image of a constitutional law professor outlining basic mechanics to the nation's chief law enforcement officer underscored the tension. It suggested a disagreement not only about facts, but about institutional boundaries. Pam Bondi responded by accusing Raskin of being driven by Trump syndrome. The phrase recast the hearing as partisan fixation. It did not clarify the confidentiality question. It did not address the compensation comparison. It reframed motive rather than substance. Raskin requested restoration of his time and continued. He reiterated that the privacy statute imposed affirmative obligations on the Department of Justice. Agencies are required to implement safeguards that prevent disclosure of protected information. If those safeguards fail, internal review and corrective measures are expected. No such review had been outlined in testimony. He emphasized that harm from disclosure is irreversible. Once names and contact details enter the public domain, they can be archived, replicated, and circulated indefinitely. Even subsequent redaction cannot erase initial exposure. For survivors who relied on anonymity as a shield, that exposure carries tangible risk. The discussion then expanded to document disclosure more broadly. Congress had requested 6 million files connected to the Epstein investigation. Approximately half had been released. 3 million remained undisclosed. Oversight authority depends on access to records, not partial summaries. Raskin cited references to Donald Trump's name appearing extensively in the files that were released. He did not draw conclusions from frequency alone. He stated that such volume heightens the public interest in full transparency. When only half of a record is available, speculation replaces clarity. Pam Bondi did not provide a detailed timeline for releasing the remaining documents. She did not describe classification criteria governing the withheld material. The absence of procedural explanation deepened concern. Oversight is weakened when documentation remains inaccessible without justification. Raskin then proposed forming a joint task force involving federal, state, and local authorities. Complex criminal networks often require coordinated enforcement across jurisdictions. The proposal offered a concrete mechanism for advancing investigations where progress appeared stalled. It was operational rather than symbolic. He asked whether the Department of Justice would support such collaboration. The response did not commit to that structure. The focus again shifted toward district-level criticism and political framing. The task force question remained unanswered on the record. As the first phase of the hearing concluded, the unresolved issues were clear. Whether the confidentiality statute had been breached remained unaddressed in detail. Whether compensation mechanisms would be considered for exposed survivors remained uncertain. Whether the remaining 3 million files would be disclosed remained undefined. The confrontation had not produced resolution. It had produced a documented clash between legislative oversight and executive resistance. Raskin anchored his inquiry in statutory language and enforcement mechanics. Pam Bondi framed the exchange as politically motivated scrutiny. Between those positions stood more than 1,000 survivors and millions of pages of investigative material. The hearing established that these questions would not dissipate quietly. It marked the opening chapter of a broader institutional dispute about compliance, transparency, and accountability under federal law. After the first round of exchanges established the fault line, the hearing did not reset to neutrality. It moved deeper into institutional territory. Jamine Raskin understood that once a witness refuses to engage a statutory question directly, the only leverage left is precision. He narrowed his focus rather than expanding it. The objective was to make evasion unmistakable. He returned to the confidentiality statute and examined its structure. The law did not merely advise caution. It imposed an obligation on the Department of Justice to prevent disclosure of identifying information belonging to survivors. That obligation required internal review procedures before document release. It required redaction standards that were not optional. If identifying details were visible in the released material, those safeguards failed somewhere in the chain. Raskin framed the issue in procedural terms. When an agency releases protected information, there should be an internal audit. There should be documentation explaining how the breach occurred. There should be corrective measures implemented immediately. None of those elements had been described during Pam Bondi's testimony. Bondi did not dispute the existence of the statute. She did not provide a step-by-step explanation of the redaction process. Instead, she returned to criticism of Raskin's district and reiterated references to Chase Mulligan. The shift did not connect to the alleged confidentiality lapse. It redirected attention toward political vulnerability rather than statutory compliance. Raskin declined to pursue the diversion. He acknowledged that local criminal cases are serious matters. He then returned to the question of federal responsibility. The Department of Justice is accountable for the handling of federal investigative files. District-level cases do not explain document management failures at the national level. The exchange tightened as he introduced the compensation comparison again, this time with greater specificity. If high-level political disputes can produce multi-billion-dollar damage claims, then tangible exposure of private citizens must be evaluated with equal seriousness. The harm from public disclosure is measurable. Threats, harassment, and loss of employment opportunities are not theoretical consequences. They are documented outcomes in similar cases. Pam Bondi did not present a compensation framework. She did not state whether survivors had been contacted. She did not clarify whether the department intended to offer any form of redress. The absence of operational detail reinforced the perception that the issue was not being addressed administratively. Raskin then pivoted to document access. Congress requested 6 million files associated with the Epstein investigation. 3 million were released. 3 million remained undisclosed. Oversight authority loses substance when half of a requested record remains inaccessible without articulated reasoning. He did not accuse the department of concealment. He asked for explanation. Classification categories, ongoing investigative constraints, and privacy considerations can justify temporary withholding. However, those justifications must be stated clearly. Silence on procedural grounds invites suspicion. Bondi characterized the inquiry as politically driven. That framing did not substitute for documentation. It did not clarify the criteria governing withheld material. It shifted the narrative toward motive rather than process. Raskin then addressed the references to Donald Trump appearing within the released files. He noted the frequency, but avoided drawing legal conclusions. The presence of thousands of mentions increases the need for comprehensive disclosure. Partial transparency amplifies speculation rather than reducing it. He emphasized that oversight is not contingent on the identity of individuals named in investigative records. Congressional review exists to ensure agencies comply with statutory mandates regardless of political implications. If documents contain references to powerful figures, transparency becomes more critical, not less. Bondi did not provide a breakdown of those references. She did not contextualize the frequency. She reiterated that the line of questioning reflected Trump syndrome. The phrase remained rhetorical. It did not engage with the mechanics of disclosure. The hearing then returned to enforcement strategy. Raskin expanded on the Joint Task Force proposal. Federal investigations can stall when jurisdictional boundaries complicate prosecution. State attorneys general and local district attorneys possess independent authority that can supplement federal efforts. Coordinated investigations are common in organized crime cases and complex financial fraud. He asked again whether Pam Bondi would support assembling such a task force. The proposal required a yes or no response. Instead of a commitment, the answer returned to district-level criticism. The absence of engagement left the proposal unresolved. Raskin clarified that the task force was not an indictment of federal agents. It was an acknowledgement that large-scale cases require layered enforcement. More than 1,000 survivors were waiting for accountability. If federal momentum slowed, collaborative action could accelerate progress. Bondi did not endorse that structure. She did not articulate an alternative enforcement plan. The record reflected a proposal and a non-response. In oversight proceedings, unanswered operational questions accumulate weight over time. Raskin then addressed the procedural rules once more, not as confrontation, but as clarification. Congressional questioning time belongs to the member. Witnesses must respond within that framework. When discussions drift into unrelated accusations, oversight becomes diluted. The explanation was grounded in long-standing committee practice. It did not introduce new rules. It reiterated existing ones. The fact that such clarification was necessary underscored the strain between the two branches. As the second phase of the hearing drew toward transition, the unresolved issues were increasingly concentrated. The department had not explained how protected information entered public files. It had not detailed a review process or corrective action plan. It had not committed to releasing the remaining 3 million documents on a defined timeline. The compensation comparison remained unanswered. The Joint Task Force proposal remained unanswered. The frequency of references within released files remained without contextual breakdown. Each of these points existed in the record without executive clarification. The exchange had moved beyond disagreement over tone. It now centered on institutional transparency. Oversight without documentation becomes rhetorical. Enforcement without explanation invites doubt. The hearing captured that tension in real time. Jamine Raskin maintained focus on statutory language and procedural mechanisms. Pam Bondi maintained focus on political framing and district-level critique. Those approaches did not converge. The second phase concluded with the structural divide intact and the central questions still pending resolution. As the hearing progressed into its third phase, the tone settled into something colder and more deliberate. The initial clash had already established the divide, and now the focus turned to consequences. Jamine Raskin stopped debating motive and concentrated entirely on institutional gaps. The unanswered questions from the earlier exchange did not fade. They hardened into a pattern. He revisited the number that hovered over the proceeding. More than 1,000 victims connected to Epstein's network. That figure was not symbolic. It represented individuals whose cases intersected with federal investigative files. Despite the scale of alleged exploitation and documented material, no new prosecutions had emerged from the Department of Justice in relation to the broader network described in the files. That disparity required explanation. Raskin examined the enforcement dimension carefully. Federal investigations often involve layers of evidence review, coordination between agencies, and prosecutorial discretion. However, when public documentation suggests systemic wrongdoing, prolonged inactivity raises legitimate oversight concerns. He did not accuse the department of deliberate inaction. He asked what steps were currently underway. Pam Bondi did not provide a detailed outline of active investigative strategies. She did not identify task groups reviewing evidence. She did not reference timelines for prosecutorial decisions. The response once again shifted toward framing the inquiry as politically motivated scrutiny. The absence of operational detail became more noticeable. The conversation returned to the 3 million unreleased documents. Raskin emphasized that oversight authority depends on access to the full evidentiary record. Congress cannot evaluate compliance with statutory mandates without reviewing the complete file set. Half access does not constitute transparency. It creates partial narratives. He clarified that classification, ongoing investigations, and privacy concerns can justify temporary withholding. However, such withholding requires articulated reasoning and defined parameters. A blanket absence of explanation does not satisfy oversight obligations. That point was procedural, not partisan. Bondi did not outline specific classification grounds for each withheld category. She did not describe phased disclosure plans. She reiterated that the hearing reflected disproportionate focus on politically sensitive names, that framing again addressed perception rather than documentation. Raskin then addressed the public trust dimension. When millions of documents are requested by Congress and half remain inaccessible without detailed explanation, skepticism becomes predictable. The Department of Justice operates on institutional credibility. Transparency strengthens that credibility. Limited disclosure without context weakens it. He returned to the confidentiality statute from a different angle. Even if the release of identifying information was inadvertent, agencies must disclose error and corrective measures. Public acknowledgement of procedural failure does not weaken institutions. Concealment of error does. The distinction mattered. Pam Bondi did not concede error. She did not announce an internal audit. She did not reference policy changes to prevent future disclosure. The record reflected defense rather than remediation. In oversight hearings, remediation often carries more weight than denial. The discussion then turned to the scope of references to Donald Trump within the released files. Raskin emphasized that frequency alone does not imply criminal liability. However, when references appear in the thousands, comprehensive disclosure becomes essential for context. Partial access leaves open interpretive gaps. Bondi did not contest the frequency claim with alternative data. She did not provide contextual classification of those references. The exchange therefore left the statistic standing without elaboration. Oversight relies on complete explanation when data points carry political implications. Raskin moved back to the proposed joint task force. Complex cases involving interstate activity frequently require coordinated enforcement. State attorneys general and local prosecutors can supplement federal investigations when jurisdictional overlap exists. The proposal was intended to accelerate accountability where progress appeared limited. He restated the question clearly. Would the Department of Justice support formal collaboration across jurisdictions? The answer again avoided direct commitment. The pattern was consistent. Operational proposals received reframing rather than response. The third phase revealed that the hearing had shifted from initial confrontation to structural standoff. Questions about privacy, document disclosure, enforcement coordination, and compensation had been raised multiple times. Direct answers remained absent. Each deflection accumulated as part of the official transcript. Raskin's focus did not waver. He avoided rhetorical escalation. He returned repeatedly to statutory language and procedural expectations. Oversight, in his framing, was not a partisan weapon. It was a constitutional mechanism designed to test compliance with enacted law. Pam Bondi maintained that the inquiry reflected political fixation. That stance remained her central defense. It did not, however, supply the detailed administrative explanation that oversight hearings typically demand. The divide between political framing and procedural accountability defined the closing moments of this phase. By the end of the third segment, the unresolved elements were unmistakable. The confidentiality breach allegation lacked a corrective outline. The withheld documents lacked a disclosure timeline. The Joint Task Force proposal lacked executive endorsement or rejection. The compensation comparison lacked departmental response. The hearing's momentum slowed not because tension dissipated, but because clarity did not emerge. Each unanswered question reinforced the perception of resistance. Oversight without substantive response leaves gaps that persist beyond the chamber. Jamine Raskin concluded this phase by reiterating the constitutional framework underlying the entire exchange. Congress writes laws and oversees their execution. The Department of Justice enforces those laws and responds to legislative inquiry. When either side resists its role, institutional friction follows. The third phase closed without resolution, but with a sharpened record. The transcript now reflected repeated statutory questions, repeated procedural reminders, and repeated avoidance of operational detail. That record would outlast the hearing itself. It would shape future scrutiny, potential litigation, and continued demands for transparency. By the time the hearing entered its final stretch, the tone was no longer volatile. It was deliberate. The sharp exchanges from earlier had settled into something heavier, defined less by confrontation and more by what remained unresolved. Jamine Raskin understood that the record now mattered more than the immediate reaction in the room. What was preserved in the transcript would outlive the moment. He summarized the structural issues that had surfaced. More than 1,000 individuals were tied to the Epstein investigation as alleged victims. Despite the volume of documentation and public attention, there had been no visible expansion of prosecutions connected to the broader network referenced in the files. That gap between allegation and enforcement was not emotional rhetoric. It was a measurable absence. Raskin returned once more to the confidentiality statute. Congress enacted language requiring survivor identities to be protected in federal disclosures. The statute did not leave room for selective interpretation. It imposed an obligation on the Department of Justice to prevent the release of personally identifiable information. If that obligation had not been met, the department needed to explain the failure and the corrective steps taken. Pam Bondi did not concede procedural error. She did not outline an internal compliance review. She did not describe revised safeguards to prevent recurrence. Instead, she maintained that the hearing reflected partisan scrutiny rather than statutory deficiency. That position preserved her political defense, but did not address the operational concern. The discussion then circled back to the 3 million unreleased documents. Congressional oversight depends on access to investigative records. When half of a requested archive remains inaccessible, lawmakers cannot fully evaluate whether executive agencies complied with enacted mandates. Transparency is not achieved through partial disclosure. It requires structured explanation for any withholding. Raskin emphasized that classified information or ongoing investigative sensitivity can justify temporary restriction. However, those restrictions must be clearly articulated. Without explanation, withheld material becomes a source of suspicion rather than procedural necessity. The department had not provided a detailed accounting of the criteria used to retain the remaining files. Bondi reiterated her framing of the inquiry as politically motivated. She did not provide a breakdown of classification categories or anticipated release schedules. The absence of administrative clarity continued through the final exchanges. The hearing therefore concluded with critical procedural questions unanswered. Raskin addressed the frequency of references to Donald Trump in the released files once more, carefully avoiding speculative claims. The issue was not presumption of guilt. It was the demand for full context. When thousands of mentions exist within half of the available material, incomplete disclosure leaves interpretive gaps. Bondi did not supply contextual analysis of those references. She did not describe how they were categorized within the investigative framework. The record therefore reflected the data point without elaboration. Oversight requires explanation alongside statistics. The Joint Task Force proposal also remained unresolved. Raskin had suggested collaboration among federal, state, and local authorities to address the scale of allegations. Such coordination is common in complex criminal matters. It accelerates investigative capacity when cases span jurisdictions. No commitment was offered. The final phase of questioning underscored the institutional divide. Raskin framed each issue through statutory obligation and procedural compliance. Bondi framed each challenge through political interpretation. The hearing became less about facts disputed and more about frameworks rejected. As the chair signaled the close of the session, the unresolved questions were evident. The alleged confidentiality breach had not been clarified. The withheld documents lacked a defined disclosure plan. The enforcement trajectory for more than 1,000 victims remained uncertain. The task force proposal remained unanswered. The confrontation did not deliver immediate accountability. It delivered a public record of inquiry and resistance. That record would shape subsequent oversight efforts, potential litigation, and continued political debate. It established that these questions would not dissipate quietly. More than 1,000 survivors remained central to the unresolved issues. Their privacy protections were the catalyst for the hearing. Their safety concerns were embedded in federal law. Whether those protections were upheld would likely face continued scrutiny. The 3 million withheld documents remained another focal point. Congressional authority to request records had been exercised. Executive compliance had been partial. The next steps would determine whether that partial compliance persisted or evolved into fuller disclosure. The hearing closed without resolution but with definition. It clarified the constitutional tension between legislative oversight and executive defense. It documented repeated questions about compliance and repeated absence of operational explanation. It demonstrated how institutional accountability is tested when political stakes are high. In the end, the session did not settle the dispute. It framed it. It left open the central question that began the confrontation: whether federal law enacted to protect vulnerable individuals was fully respected by the agency sworn to enforce it. That question remained active beyond the chamber walls, carried forward by the transcript that now recorded every exchange.